A Supreme Court decision came down that fundamentally changed gun rights in America. And here's the problem. Most gun owners completely missed what it actually means for them. I'm talking about New York State Rifle and Pistol Association v. Bruen, decided June 23, 2022. And before you click away thinking you already know about this case, let me tell you, what the court actually did goes way deeper than just striking down New York's carry law. They created a completely new legal framework that invalidates decades of gun control, and most gun owners have no idea how to use it to challenge restrictions in their own states right now. This wasn't just about carry permits. The Supreme Court, in a 6-3 decision written by Justice Clarence Thomas, eliminated the legal standard that courts had been using to uphold gun control for over a decade and replaced it with a test that makes nearly all modern gun restrictions unconstitutional. We're talking assault weapon bans, magazine limits, sensitive place restrictions, age restrictions. All of it now has to survive a historical test that most laws cannot pass. Hit that subscribe button right now, because what I'm about to show you is how this decision is quietly being used to dismantle gun control across America, what you can legally do today that was prohibited 2 years ago, and the critical actions you need to take before states find workarounds to re-restrict your rights. Here's what makes this so significant. The court didn't just rule on one law. They changed the entire rulebook for every future gun case. And the lower courts are now using this framework to strike down restrictions that have been on the books for decades. But it's happening quietly in district courts and appellate courts that don't make national news. By the time I'm done, you'll understand exactly how this affects you, regardless of which state you live in. Number 1, here's what the Supreme Court actually changed that everyone missed. Most coverage focused on the obvious. New York's may-issue carry permit system was unconstitutional. You no longer need to prove proper cause to get a carry permit. But that was just the surface. Here's what the court really did. They eliminated means-end scrutiny entirely. For over a decade, since a case called United States v. Heller in 2008, lower courts were using a 2-step test. Step 1, is this law covered by the Second Amendment? Step 2, if yes, what level of scrutiny applies? Strict, intermediate, or rational basis? Courts almost always chose intermediate scrutiny, which let them weigh the government's interest in public safety against your right to bear arms. And guess what? Public safety almost always won. That's how assault weapon bans, magazine limits, and waiting periods kept getting upheld even after Heller said the Second Amendment protects an individual right. Bruen threw that entire framework in the garbage. Justice Thomas wrote, "The government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation." That's it. No more balancing tests. No more asking if a restriction serves an important government interest. The only question now is there a historical analog from the founding era or Reconstruction era that justifies this modern restriction? If the answer is no, and for most modern gun control the answer is no, the law is unconstitutional. Period. Here's the 3-part test courts must now use. Is the restricted activity covered by the plain text of the Second Amendment? If it involves arms and the right to keep and bear them, the answer is yes. If yes, the government must prove the regulation is consistent with historical tradition. They must show similar restrictions existed when the Second Amendment was ratified 1791, or when the 14th Amendment was ratified 1868. If the government cannot show historical precedent, the law is unconstitutional. No balancing. No deference to legislatures. The restriction falls. This is an earthquake in constitutional law, and here's why. Almost no modern gun control has a historical analog from the 1700s or 1800s. Assault weapon bans? Didn't exist. Magazine capacity limits? Didn't exist. Sensitive places like parks and public transit? Not historically prohibited. Age restrictions beyond 18? Not supported by history. If you're finding this helpful, imagine what you'll learn when I break down exactly which gun laws in your state are now vulnerable and how gun rights groups are already challenging them. Subscribe so you don't miss it. Number 2, here's how this is quietly dismantling gun control across all 50 states. Since Bruen came down in June 2022, lower courts have been using this historical test to strike down gun laws that have been on the books for decades. And this is happening right now in cases most gun owners have never heard of. Laws already struck down using the Bruen framework. Category 1, age restrictions. Minnesota, Virginia, and Texas federal courts have struck down laws prohibiting 18-20-year-olds from carrying handguns. The historical evidence shows adults at 18 had full Second Amendment rights at the founding. Category 2, sensitive places expansion. New York's attempt to ban guns in all places of public assembly has been blocked. Courts ruled the state cannot simply declare every public space sensitive. Historical sensitive places were limited to legislative buildings, courthouses, and polling places, not Times Square, subways, or parks. Category 3, licensing and registration schemes. Delaware's requirement to get a license before buying a handgun is being challenged under Bruen standards. No historical tradition required prior permission to purchase common arms. Category 4, assault weapon and magazine bans. Illinois' assault weapon ban, passed January 2023, is facing multiple challenges, arguing that AR-15s and similar rifles are in common use and protected by the plain text of the Second Amendment, with no historical tradition of banning entire categories of common firearms. California and New Jersey's magazine capacity limits are being relitigated under Bruen. Courts previously upheld these under interest balancing, but there's no historical analog for limiting ammunition capacity. Category 5, carry restrictions. Hawaii's ban on openly carrying firearms is being challenged. Historical evidence shows open carry was the norm, not prohibited. Category 6, location-based bans. New Jersey's ban on carrying in your own vehicle without a permit has been challenged. Historical evidence shows no tradition of prohibiting arms in personal conveyances. The pattern is clear. When forced to show historical justification, states cannot defend modern restrictions. The Bruen test is a wrecking ball for gun control. Here's the state-by-state breakdown of vulnerability. Most vulnerable, 10+ laws likely to fall. California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Illinois, Connecticut, Delaware, Rhode Island. Moderately vulnerable, 3 to 5 laws at risk. Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, Florida. Least vulnerable, 0-2 laws affected. The 25 constitutional carry states with minimal restrictions. If your state is in the first 2 categories, laws you're currently following may soon be declared unconstitutional. The question is, how do you take advantage of these changes legally? Number 3, here's what you can now do legally that was prohibited before. Based on Bruen and the cases flowing from it, here are rights you can now exercise or will soon be able to exercise. 1, carry without proving special need. All may issue states became shall issue after Bruen. If you previously couldn't get a carry permit because you didn't face specific threats, you can now apply and must be approved if you meet objective criteria. Affected states, New York, California, New Jersey, Maryland, Massachusetts, Hawaii, all forced to switch to shall issue. 2, carry in more public places. States that responded to Bruen by expanding sensitive places to include public transit, parks, entertainment venues, and houses of worship are seeing those expansions blocked by courts. What this means, in New York, California, and New Jersey, you can challenge signage and restrictions in locations that aren't historically sensitive places. 3, purchase firearms at 18-20 years old. Federal courts in multiple circuits have struck down laws prohibiting handgun purchases or carry for 18-20-year-olds. While some cases are on appeal, the trend is clear. Age 18 marks adulthood for Second Amendment purposes. 4, own standard capacity magazines. Magazine limits in California, 10 rounds, New Jersey, 10 rounds, and other states are being relitigated. Under Bruen, states must show historical tradition for capacity limits, and they cannot. 5, purchase without arbitrary delays. Waiting periods that extend beyond background check time, California's 10 days, Florida's 3 days, have weak historical support. Challenges are being filed arguing delays beyond verification are unconstitutional prior restraints. Quick legal note, this is educational information about the Bruen decision and its ongoing effects on gun laws. This is not legal advice. Gun laws are changing through ongoing litigation. Always verify current requirements in your jurisdiction and consult with a firearms attorney before making legal decisions. Hey, 70% of people watching right now aren't subscribed. Don't be part of that group. Join the community of gun owners who stay informed about their expanding rights. Click that subscribe button because next week I'm revealing which states are complying versus which are fighting these court decisions with workaround legislation. Number 4, how states are responding. Compliance versus resistance. State responses fall into 3 categories. Category 1, immediate compliance. Constitutional carry states and most shall issue states claim they were already compliant. Texas, Florida, Arizona, Georgia, Tennessee, Ohio, Indiana, these states made minimal or no changes post-Bruen. Category 2, grudging compliance with maximum resistance. New York, California, New Jersey, Hawaii. These states technically switched to shall issue, but immediately passed new laws designed to restrict carry as much as possible within Bruen's framework. New York's CCIA Concealed Carry Improvement Act banned guns in an extensive list of sensitive places, including public transit, parks, theaters, bars, Times Square, and any private property without express permission. Required 16 hours of live fire training, invasive social media review, character references. California's SB2, similar approach, massive expansion of sensitive places, stricter permitting requirements, insurance mandates. New Jersey's legislation banned carry in casinos, libraries, entertainment venues, public parks, beaches, essentially anywhere people gather. The problem for these states, courts are blocking these workarounds. Judges are calling them what they are: attempts to nullify Bruen through legislative gamesmanship. Category 3, doubling down with new restrictions. Illinois, after Bruen, passed one of the nation's strictest assault weapon bans. The state is betting it can convince courts that weapons of war aren't covered by the Second Amendment's plain text. Oregon passed Measure 114, requiring permits to purchase any firearm, limiting magazines to 10 rounds, and mandating training. It's currently blocked by courts applying Bruen. Gun rights organizations, Second Amendment Foundation, Firearms Policy Coalition, NRA, are challenging every workaround. And they're winning. Under the Bruen standard, restrictions need historical support, not creative legislative drafting. Number 5, why this framework is more powerful than most gun owners realize. The Bruen decision's historical test does something no previous gun rights case did. It removes judicial discretion to weigh policy preferences. Under the old intermediate scrutiny test, judges could ask, is this restriction reasonable? Does it serve public safety? And anti-gun judges would always answer yes. Under Bruen, judges must ask, did similar restrictions exist in 1791 or 1868? That's a historical question with a factual answer. Modern policy preferences are irrelevant. Here's why this dooms most gun control. Assault weapon bans. Semi-automatic rifles with detachable magazines existed in the 1800s. Evans repeating rifle, Winchester 1903. No tradition of banning entire categories of common arms. Magazine limits, repeating firearms with high capacity existed. No historical limits on ammunition capacity. Sensitive places expansion. Historical sensitive places were extremely limited. Legislatures, courthouses, polling places during voting. Not entire cities or all public transit. Training requirements, no founding era or Reconstruction era requirements for government-approved training before exercising rights. Red flag laws. Civil seizure of firearms without criminal conviction has weak historical support unless there's imminent threat with strong due process. The framework also prevents analogical reasoning abuse. States can't just point to any vaguely similar historical law. The court said the analog must be relevantly similar in both burden and justification. This is why Bruen is more important than Heller or McDonald. Those cases recognize the individual right. Bruen made it enforceable. Number 6, what this means for future gun rights litigation. Bruen creates a litigation roadmap for gun rights organizations, and they're following it systematically. Current challenges using Bruen. Assault weapon bans in California, New York, New Jersey, Illinois, Massachusetts, Connecticut, Maryland. Magazine capacity limits in 9 states. Sensitive places expansions in New York, California, New Jersey. Carry permit training requirements in multiple states. Age restrictions, 18-20-year-olds, on purchases and carry. Licensing schemes that require permits to purchase. Waiting periods beyond background check time. Ghost gun regulations that restrict unfinished frames and receivers. Firearm registration databases. Ammunition purchase restrictions. Every single one of these is vulnerable under Bruen's historical test. For Congress, new federal gun control is essentially dead. Universal background checks might survive as a narrow verification system, but sweeping bans, national licensing, or mandatory registration cannot meet the historical standard. For state legislatures, the era of experimental gun control is over. Every new restriction must have historical grounding from day one, or it will be immediately enjoined. For courts, every gun case now begins with, show me the founding era or Reconstruction era analog. If states cannot, they lose. For gun owners, this is the most favorable litigation environment in American history. Number 7, your action plan to protect and exercise your expanded rights. Here's exactly what you need to do to take advantage of Bruen and protect your rights before states find new workarounds. Action step 1, know what changed in your state. Go to your state's Attorney General website or check with local gun rights groups, state-level SAF, FPC, or NRA affiliates to learn. Did your state have may issue carry that's now shall issue? What new restrictions did your state pass post-Bruen? Which restrictions are currently blocked by courts? Action Step 2. Apply for carry permits under the new standard. If you're in a former may-issue state, NY, CA, NJ, MD, MA, HI, apply for your permit now. The good cause requirement is gone. If you meet objective criteria, they must approve. Action Step 3. Document illegal denials or delays. If officials deny your application based on subjective standards, delay beyond reasonable processing time, or enforce restrictions that courts have blocked, document everything. Save all correspondence, screenshot denials, record dates and times, contact gun rights legal foundations. This documentation is grounds for federal civil rights lawsuits under 42 U.S.C., paragraph 1983. Action Step 4. Support litigation organizations. Bruen only happened because groups like SAF, FPC, and NRA litigated for years. They're now challenging the next wave of restrictions. Support them financially or become a member. These organizations need funding for the 50-plus active challenges to post-Bruen workarounds. Action Step 5. Challenge sensitive place restrictions. If your state banned carry in parks, public transit, or other non-traditional sensitive places, join a legal challenge or file your own with attorney support. These restrictions are facially unconstitutional under Bruen. Action Step 6. Stay informed about ongoing litigation. Subscribe to legal update newsletters from Second Amendment Foundation, Firearms Policy Coalition, your state's gun rights organization. Court decisions are coming down weekly. Knowing when restrictions are blocked helps you exercise rights immediately. Action Step 7. Vote and advocate. Bruen exists because President Trump appointed Justices Gorsuch, Kavanaugh, and Barrett. The court's composition determines whether these victories continue or get reversed. Judicial appointments at every level, district, appellate, Supreme Court, determine how Bruen is applied. Elections have direct consequences for gun rights. Also contact your state legislators to oppose workaround bills that technically comply with Bruen while maximally burdening rights. The Supreme Court's Bruen decision didn't just strike down New York's carry law. It eliminated the entire legal framework that courts used to uphold gun control for over a decade and replaced it with a historical test that most modern restrictions cannot pass. No more balancing your rights against government interests. The only question now is, did similar restrictions exist in 1791 or 1868? For assault weapon bans, magazine limits, expanded sensitive places, training mandates, and licensing schemes, the answer is no. Since Bruen, lower courts have been quietly dismantling gun control across America. Age restrictions, sensitive place expansions, may-issue systems, and purchase permit requirements are falling. More challenges are coming. States are responding with workaround legislation designed to technically comply while maximally restricting. New York, California, and New Jersey expanded sensitive places to cover entire cities. Illinois banned assault weapons. Oregon requires permits to purchase. But courts are blocking these workarounds because the historical test doesn't allow creative gamesmanship. Either there's founding-era precedent or the law is unconstitutional. This is the most important gun rights framework in American history because it's enforceable. Heller and McDonald recognized the right. Bruen gave you the tools to defend it in court. Most gun owners have no idea how to use these tools. They don't know what they can now legally do, which restrictions are vulnerable, or how to challenge state resistance. Subscribe right now, because next week I'm breaking down the specific lawsuits challenging assault weapon bans, magazine limits, and sensitive place restrictions, and showing you how to join these challenges in your state. Share this with every gun owner you know. This decision affects all 50 states, but most people only heard about New York's carry law. Remember, this is educational information about Supreme Court decisions and their effects. Always consult with a firearms attorney for specific legal situations. The constitutional framework just shifted in your favor. The question is, will you use it before states find new ways to restrict? Thanks for watching. I'll see you in the next one, where we break down the first post-Bruen challenges to assault weapon bans and why states are losing.